Well, welcome to episode 9 of the Wright County Restoration Project podcast. We're happy to be here. My name's Jamin.
And I'm Sam.
And we are continuing right along with the Bill of Rights, the first 10 amendments to the Constitution of the United States. And today we're looking at amendment number 6, and then perhaps, if all goes well, we can stick in kind of foray into the 7th as well, not one that might take too long to talk through.
For sure.
But the 6th Amendment's pretty important.
It is, and it has a lot baked into one amendment. There is about 7 rights that we see come from this one amendment. So there's a lot there to unpack. So I can why don't I just go ahead and read the amendment, and then we'll start breaking it down.
Sounds great.
So the 6th Amendment goes like this. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process of obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So that's the 6th Amendment.
Mm-hmm. Yeah, and as we look through it, like you said, there's quite a bit there. And in many of these things, as we kind of look through it, there's a good deal here other than this trial by jury where a person might get a summons to be on a jury. For the law-abiding citizen, many of these things don't really necessarily touch our everyday life. But I know that as I work go in chaplain in a jail setting, these things become very important.
They do.
And the system and the rights that are secured within them are not only important to those who violate the law, but they do kind of set us apart from many other cultures and civilizations as it relates to our legal system.
They do, and it's really interesting because this, especially the trial by jury portion, is very important to the founders. We can tell this by the amount of times it's mentioned 4 times in the Constitution and Bill of Rights. And it's something that right of trial by jury isn't a new thing to these founders. We see it in William Blackstone's law. He is quoted, and I think I've quoted before, but he says it's the palladium of English liberty, that it's something that is crucial to English liberty. It's being not only a right to a trial by jury, but a jury of your peers, people who would be your countrymen, as it were. It's not the elites judging the average person. It's your countrymen coming in, hearing the case against you, and having that trial by jury. And it's something that allows for justice to be done in situations. And like we've said before, yes, there may be cases where a trial by jury lets someone go who, in all cases probably did commit a crime. But the system isn't set up to catch everybody. The system's set up to make sure that a law-abiding person, innocent person caught up in the system for some reason, shouldn't be punished.
Right, absolutely. And we'll walk through there, and we'll kind of get to that point in just a minute. As we go through this, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. So the first thing that we see is this right to a speedy trial idea.
Yes.
Very similar to what we might have seen with capital offenses and the idea that they were not able to be held indefinitely for a capital offense. And then, of course, due process on top of that, as we discussed last time. We see here this idea that you can't hold a person indefinitely, and we can only imagine, and perhaps other cultures, maybe some people who are familiar more so with other cultures outside of the West could attest to this idea where a person sits indefinitely, waiting for their court date, waiting for their trial, waiting to be heard, waiting to have their right to appeal, and all the while they are imprisoned, or their freedom, their liberty, life, liberty, and property have been pulled from them.
Right.
One of the things that we often don't think about when a person is in jail or prison is that they have lives on the outside. They have a job.
Absolutely.
They have property. Maybe they're renting a house or they pay a mortgage. And if they have no means by which to continue doing those things, even if someone were falsely accused, those 30 days in jail, those 60 days in jail, if it were to become 120 or 200 days in jail, might not just strip from them the liberty of that time.
Correct.
In a misunderstanding, but could actually strip from them everything on the
Yes.
outside.
Yes.
If they're farmers, it might strip from them the entire harvest. It could really destroy a lot more than just the singular amount of time that they're incarcerated.
Absolutely, and that's something that you do see in European history, where rulers that were acting as a despot would often take people who had some means, had some monies, put them into jail for whatever reason, but maybe they didn't even have to tell them for what reason,
Sure.
and then get a large payout from them just to get them to be released or whatever. So there was definitely a way that the criminal justice system in the monarchy systems of Europe had been abused, and that this was something that that we needed to have that speedy trial in order to not just leave someone in jail indefinitely just because we didn't like something about what they were doing or saying, but there needed to be a clear-cut case put against them to actually incarcerate them for a longer period of time.
Absolutely. And then the second element here, which before we get to the impartial jury, is a public trial.
Yes.
And once again, it does not take much imagination to think through why that is so important. And nowadays, our media class has a definitive lack of curiosity as it relates to scandals or injustices or such. They're making up injustices while they're ignoring true injustices. And yet the idea that you could close the doors on a trial and there could be a closed-door decision as it relates to somebody's future is one that still conjures up some really egregious thoughts and connotations within a society where things can be done, the fate of a person can be decided behind closed doors, away from the public consciousness. And
Yes.
so a person gets taken away, similar to what we might think in France in the days when Napoleon was on Elba and such, and there was just a great deal of paranoia around sedition and such, where people are just taken and they're disappeared. And and nobody knows what happened. Nobody knows what the charges were. Nobody knows what happened in the trial. You hear what happened in the trial, but nobody had the right to be a part of that trial.
Correct, and that allows for all kinds of things to be drummed up about a person, and as we'll continue on further, even the right to see who your accuser was and those kind of things, where things could be brought before you, a case could be brought against you, you might not even be able to speak up in your own defense, and you get life in prison for whatever reason, and maybe it was a mistake, maybe it was an intentional trying to silence you, put you away for good, that type of thing, and that sadly those things were fairly common in the European countries.
Yeah. And this is perhaps a good time to bubble up and remind our listeners about the nature of the Constitution as it relates to enumerated powers and how very much the founders recognized the capacity for mankind to be corrupted and for mankind to be evil. And we think of, again, that contrast between humanism and Judeo-Christian worldviews, where humanism assumes that man in his default state is naturally good, and that given the right set of circumstances, he will become his best self. And what we find from the scriptures, for all have sinned and come short of the glory of God. There is none that seeketh after a God. There is none that do right. There is none that is righteous, no, not one. And we find in the Word of God this intrinsic recognition, and a recognition that comes back around into the Constitution and Bill of Rights, that there is none that are righteous. And so we are going to assume, in some ways, assume the worst of our elites, assume the worst of our leaders, assume the worst of our judges, assume the worst of our politicians, and hoping for the best, and hence all of the opportunities to vote and such,
Yes.
while simultaneously assuming that if a system can be closed down and can be harnessed for the good of a corrupt few, it will be. And
Yes.
so we reduce the ability for that corrupt few to have a system that lacks accountability, and through many eyes and through that curiosity of the press and of the people, there is a natural safety.
Absolutely. Absolutely.
Well, that brings us to kind of the impartial jury.
Yes.
So a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. So we kind of do have two things there. We have the impartial jury, and then we have the locality of the jury. And of course, this goes well beyond just American jurisprudence, this idea of a jury as you spoke of.
Right, and it's important not only that it is a jury of your countrymen, but also close countrymen,
Yes.
countrymen from, as we would see it, the same county area, generally, at least in America today, so that it's people that understand, even what your life was like in some way, shape, or form. That it's not you being judged by someone in another state,
Yeah.
group in another province or jurisdiction, that type of thing. That there's a clear understanding. These are your neighbors, as it were, coming together and hearing this case brought against you. They are able to hear things for you and things against you, and then make a decision as that group as to what they would pass on as a verdict.
Yeah, and I don't know that it could be stressed enough how important this locality element is. Obviously, in the United States, we find ourselves in a country that is very diverse culturally.
Yes.
If you go from the West to the South to the Northeast to the Midwest, you have the Texas South versus the Florida South. You have the Panhandle of Florida versus the actual peninsula of Florida, and all of these are very different cultures.
Absolutely.
And in some ways, the nature of actions and consequences, it must always be weighed within the considerations of the culture in which you are, so that a person in New York could perhaps never understand a motivation or a thought or an action from a person in flyover country,
Right.
whereas other
Right.
people in flyover country have a connection there that would be important. This is also very important in what we've seen lately, speaking about law enforcement. One of the things that's been very troubling to me over the course of this past little while in our discourse and in society has been this idea of naturally abolishing the police, but the concept of federal oversight
Yes.
of police. And anytime, and this is an important thing to think about for all of you who are listening, anytime something is federalized,
Yes.
anytime something goes to the federal level as opposed to the state or local level, you are ceding power over your locality and your culture even to those who may not share your culture, who may not share your thinking on things. And sometimes sometimes the country cedes it, sometimes, such as with the abortion debate in Roe v. Wade, it was just stolen from the states. The states lost the opportunity to have that debate through a Supreme Court fiat. But with policing in particular, one of the tremendous, powerful things when you think of other cultures and the way police are, or a military police system in other cultures, the power of policing in the United States is that it's local,
Right.
which means you don't have some guy sitting in some ivory tower in Washington telling some policeman who has absolutely no connection to a county or to a locality to go and arrest people within it. And in doing so, these are just nameless faces to them.
Yes.
Whereas if the guy who is a sheriff's deputy who lives down the street from me is told to arrest me, he knows me. He knows the culture in which we live. He's a part of he lives in Buffalo like I do, and there is a connection of him not just to his job, but of him to his community. And that's really important, and I think that we see that element here bubbling up as it relates to a jury, that this connection to a state and a district where the crime has been committed means not necessarily that they have a connection even to the criminal, because the crime may have been committed by an out-of-towner, but they have a connection to the crime because it's their community that was violated. It's their community that was harmed by this crime.
Absolutely.
Or perhaps not, in the case of him being innocent.
Right, and that's something that is key to having, that there can be pros and cons of having things local, but there are far more pros to having local control in any situation. That wrongs can be righted much quicker, and that there is an understanding amongst a neighborhood, a community, a town, of what's right and wrong, what's acceptable in that community, and that having that in law enforcement as well as even in schools or in local government is important, rather than ceding if you think about public works, roads and sewer and water and electricity and all those things. While some of it does get generally, however the city decides to have those things played out. But if there's a problem with any of those, it's far easier to fix that problem if it's a local group and body making that decision, rather than having to go lobby to some large federal bureaucratic system to get that done. Yeah,
and you mentioned pros and cons, and I wholeheartedly agree with you. Even in the church, we face this idea where you find church systems that are very broad and have a large hierarchy, and that hierarchy allows things to get done. It means that money can be funneled from one place that has more of it to one place that has less of it. It means that there can be a sharing of the load and a sharing of the burden in these things which have a natural value. But the problem, as we've seen it throughout church history, in the same way that we see in top-down government systems, is that when you have small local control, a single locality can be corrupted, and it might be able to be corrupted, in fact, quite easily, maybe easier than the whole broader system. But it's only a single locality, and that's easy to clean up. But when the top-down system gets corrupted, it's almost impossible to root out the corruption at that point, be that a government, be that a church system, be that any sort of a top-down system. When the corruption comes from the top, it filters down. That top person is able to filter into all of those lower positions, said corruption, and then it's just there's too many heads to cut off at that point, and that becomes a problem. So again, this idea of the jury being local, a tremendous way of protecting both the community in which the crime was committed, and in many cases, no doubt, protecting the criminal or the accused. We'll not say the criminal, protecting the accused from a rigged system.
Absolutely, and that's that. Even on a side note, like you were saying, having that that local can be good, but even in law enforcement or in a church setting or in a community setting, it does come ultimately down to people governing themselves and not allowing corruption into a local government. In years past, I worked in Juarez, Mexico for a while with a missions organization. It was a very clear picture of what happens when local police get so corrupted, in this case by the drug cartels, that the federal police did have to come in, and then the military had to come in, and it was a complete mess. And it's still reeling from the issues that have been going on in Mexico and with the cartels and drugs. But in that case, we've talked about people governing themselves.
Yes.
And that's such a key thing, that if people in government, local or federal, are going to allow corruption within their ranks, allow corruption in their own lives, you can't expect any better from the people around you, from the systems around you, and a country that or a community that allows corruption within its government is soon to fall and is going to not do justice anymore to its people.
Yep. And you bringing that up again, I don't know that we can stress enough how very much this document relies upon moral self-governance.
It does,
and once again, that is a call out to each of us who are thinking through these amendments to remember that we must have a system in place, a moral and an ethical system. It is not enough for us to live by the seat of our pants, to live by a relative truth system, because if every man can do that which is right in his own eyes, he will do whatever whatever works best in his self-interest. And as we compare that, again, between humanism and Judeo-Christianity, the secular humanistic philosophy is intent on the idea that man will produce his best self. And this is simply something that the Word of God refutes entirely. And as the Word of God speaks toward the future, the prophecies continue to refute this idea. And I think in many ways this is probably the most dangerous thing as it relates to the nature of our society right now. It's not necessarily even the ignorance of the Constitution itself, though that's a problem, but the fact that even regardless of whether or not people understand the Constitution or don't, if they don't maintain that worldview whereby we are intent upon moral self-governance under a system of intrinsic rights and expectations that are higher than just our society, that extend beyond just what we believe is right, then we will inevitably fail to want the Constitution in our society, and our society will no longer want it, and then at some point will reject it and will replace it if our society does not maintain this understanding of moral self-governance through really the law of God.
Absolutely.
And thus a call for our own introspection and self-reflection. You have to know what the Word of God says, and you have to understand your relationship to God through it, because if you do not understand it, if you are just hanging on to traditions of patriotic liberty, and you're just holding on, well, that might work for you, but will it work for your kids, and will it work for their kids? Or at what point will this humanistic philosophy, which is purveying our culture, find its way into our society to the point where our society will look at this document, the Constitution, Bill of Rights, and it's happening right now among tech billionaires, and they will say this Bill of Rights was wrong. They will actually begin to cry out that this Bill of Rights needs to be undone. Yeah. And at that point, it doesn't matter who knows what it says, if the people that know what it says simply believe that the document is wrong.
Right.
Well, let's continue on. We speak to this district that has been previously ascertained by law. That would be a legal question, not really one of particular note, other than as it would be each individual's laws of ascertaining the districts, counties, localities, whatever it might be. And to be informed of the nature and the cause of the accusation. You spoke to this a little bit, the right to be informed and to know the accusations against you. Right,
and that's something that, again, the founders saw abused and needed to be put right and put clearly in these documents so that they would not be in jeopardy of others coming along and passing judgment on someone without them even knowing why this judgment was being passed.
Yep. And again, that happened quite a bit in Europe. The idea that there would be no statement of a crime, a person would just basically be put down the memory hole. And their family would wonder where they went, and they would ask what the accusations and what the crime was, and there would be no response of sorts, or there would be something that's so broad that there would be no capacity to defend against it. And of course, this happened quite a bit in the USSR as well, as it would relate to very broad and ambiguous charges or no charges at all, which is simply and to put it very bluntly, it's just injustice.
It is.
There's no other reason for it but simple injustice.
Right.
So that's to be informed of the nature and causes of the accusation, but also to be confronted with witnesses. And of course, this has a few exceptions throughout time as far as certain cases with minors and whatever else. may be for privacy reasons, but as a general rule, another extremely important thing that a witness be willing to confront the accused and publicly do so.
Absolutely. The confrontation clause, as it's called in the Sixth Amendment, is really important. English history has some interesting things. Even one of the early explorers to America, Sir Walter Raleigh, was put to death based on an accusation of someone who he didn't get to face his accuser, which is kind of a crazy thing in our day and age to think, wow, that could happen. But it did happen in England. And so this was something that was near and dear to the founders, and they put it in there to have that ability to face your accuser, and to have your legal helps, whoever that may be, cross-examine that person, along with the party bringing the accusation and bringing suit against you can bring their witnesses. You can bring your witnesses. They can be cross-examined by both parties, and that allows for a clear understanding as much as possible of what the case is set before you, and allows for the jury and the judge to then make an informed decision.
Yeah, and you mentioned that there is another part of this, to have a compulsory process for obtaining witnesses in his favor, to be able to speak with people, and to the right to self-defense,
Right.
not in the sense of the Second Amendment, but the right to defend yourself and have your day in court with your witnesses, and to be able to face your accuser, and all of these important elements, which once again we take for granted, but which many places in history have not afforded to the accused, and very, very important for justice.
Yeah. Well, and that flows right into the next one, which is the right to counsel,
Yes.
Which is kind of the wrap-up of the Sixth Amendment. And interestingly, the founders saw this as a right, but it's only in recent times that we actually have laws put on the books. It was actually in 1932 that the Supreme Court put in that the government was actually obligated to give you a public attorney to come in and help you with your legal case, that it was an actual right to have an attorney. This was just a right so that you could bring someone in. It wasn't necessarily funded by the state before this. But it was something that they did see as important, and in this case, they're protecting from the government saying, well, you have to defend yourself and you can't bring anybody else in to help you through these legal things and all that, where someone, while they may be innocent, maybe doesn't understand the legal system or doesn't understand the case that's brought against them, and just isn't skilled in the legalese and the way that it should be presented and all those things. And so this was a right to be able to bring in counsel on into a case when a case is brought against you. And like I said, in the past years, it has become where the government, if you can't afford an attorney, the courts will provide one for you. And that's been not necessarily a bad thing, but it's also sadly, those people that are appointed, if you can't afford someone to defend you, tends to be just overworked and not able to defend people in the way that possibly they deserve. But at least it's something, and it's definitely a huge difference from what the founders were trying to guard against.
Yeah, and that's an important last point that you make there as it relates to those, and of course dealing with the jail again. There is much of what we see here is exacerbated by kind of a class system, the haves and the have-nots idea, and yet simultaneously, and this is something I keep trying to encourage the people that I talk with in the jail to remember. They often complain about the nature of their appointed counsel, and rightfully so, because like you said, they're overworked. They don't fight for the client as much as they just work deals oftentimes with the district attorney and such. But what a unique thing that they even get that.
Yeah.
That they have an advocate in their corner at all, as opposed to in many places where, once again, you can't afford an attorney, and you either cannot wade through the legal process well enough to do anything, or simply put, again, you go down the memory hole.
Yeah, absolutely. And that's, the interesting thing, and the thing to keep in mind when you're looking at this document, and how well studied, well read, and the wisdom of these men that put this document together. This is a very unique thing, and it's a very unique document in history. And it's good to remember that many of these things, while bits and pieces of them we do bring from English common law and other places, really you don't really see any document like this that's put together and then stood the test of time, but that also that these things are all put together and that these things are there to protect the people. And we don't see them. Also, if living in America, growing up in America, we see a lot of these things as our rights, unquestionably.
Right.
In the rest of the world, there are many places where and where these things may be actually on the books, but are they enforced? Do you actually have those rights? Do you actually get to exercise those rights? Or, like we were talking about earlier, have things become so corrupt that, yes, you can get, certain government helps, but it sure helps if you can, help out the government official with a few $100s here or there to make things move a little more freely in government. And that's definitely the case in a lot of other countries, not to disparage them per se, but sadly, when corruption starts to come in, when people are willing to take a bribe, that's a biblical concept, where the Bible is very clear about someone willing to take a bribe, that being able to, that allows you to subvert justice, that allows you to sway a ruler of the people, as it were, and that's one of those steps down a slippery slope of just a government becoming completely corrupt.
Yeah, and that's what the Bible does speak of, is that gifts blind the eyes of justice, and it's a good reminder that not all worldviews and not all cultures are created equal.
Absolutely.
That as we look at cultures around the world, it's not to say that they do not have redeeming qualities that perhaps have even been lost within our culture. Many cultures today still retain a strong respect for the elderly, that our culture left in the 60s and 70s. However, and that's very important and indeed even biblical, but recognizing that the Judeo-Christian worldview upon which the Western world was built has afforded us such unique opportunities for justice in particular in our country as we see it. Well, let's hasten on to the Seventh Amendment. We might as well get that one done. I think the Eighth Amendment is going to take a little more time, so we'll do that next time. But why don't you go ahead and read the Seventh Amendment, and then we'll talk about it.
All right, and this is good because it kind of does dovetail with the Sixth Amendment. So hopefully we can get through this, and it's you'll see some parallels here, and some of the topics that we've already talked about will fit nicely with this. So the Seventh Amendment is as follows. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So that's the Seventh Amendment, and just to kind of start by kind of a little bit of history background on that, we're getting back into that trial by jury. This one specifically, though, was brought out, and if you listen back to one of our previous podcasts, we do read the Declaration of Independence, and there's a long list of grievances there. One of those grievances that gets bore out and we see brought up here is about something, and we talked about it a little bit, it's called the Navigation Act, but it was something that the British put into place, and they were basically limiting the colonies and British citizenry from who and what they could buy in the national commerce. That you could only buy things that were approved by the British government, whether that was you could only buy tea from the East India Company, those kind of things. And so and that unless you had a stamp of approval or some approval of the crown on the products that you were going to trade and purchase, those were considered contraband. So if you had something that didn't have the stamp of approval on it, that was contraband. And the colonies leading up to the Revolutionary War, there's a pretty healthy black market going on of people buying things, better deal, but hey, in our case, it would be as if you can't go to that grocery store, or those items in that grocery store you can't buy because they're not approved by the king. And maybe you did buy them, maybe you went around back and bought them, with cash or whatever. But if you're found possessing those items, then you are then prosecuted by the king.
And that brings up the Fourth Amendment again, and the
Correct.
idea that they have to have a definitive search and seizure.
Yeah, to be secure in your property. And so this specific amendment was very important, and they wanted to make sure that they were, that's why it's talking about the $20 and those kind of things, that someone was brought before it, and that the king actually, right before the revolution, was disbanding the use of juries. Because if you put together a jury, a group of your peers, which was happening in the colonies, and you're in court, and all your buddies over there who maybe were dealing in black market goods as well, and they were getting off, they basically with this, and they couldn't catch them, so they were basically disbanding juries, doing away with juries, and that wasn't something that the founders were very positive about. And so that they wanted to really make sure, kind of really, make a clear statement about having that jury to be of your peers, to be able to discuss and to give judgment on a certain case that's brought in court.
Yeah, and this brings up an interesting idea as it relates to the jury itself, and it's one that flies around in legal issues or in legal quarters about jury nullification, and the idea that a jury can that they can, in protest, declare a person not guilty. And in some senses, there's an opportunity to be a last check against legal corruption when there is still a jury system in place, by simply overriding the nature of the law itself because the jury decides that the law is unjust.
Yeah.
And so there is a hot debate today, if you're not familiar with it, around the concept of jury nullification, and various places where people have wanted to educate others about the nature of the jury system and the power that a jury might have if it deems a law to be entirely unjust, to simply invalidate to declare a man not guilty, though he did in fact commit the crime, simply
Yes.
by virtue of the fact that the law that he offended in and of itself is unjust. And so there maybe is a little bit of a shadow of that sort of an idea, at least in the history, where they were letting guys off because the king's edicts were not quite just themselves.
Right. Well, and we see in a little bit, it's kind of that we the people type thing, where a group of citizens who are brought in can, like you said, kind of nullify a law that's on the books just by their refusing to convict a fellow neighbor in doing wrong when they are in fact are sympathetic
Yes.
to his cause. This was a really, really important thing to even the states during the ratification for the Constitution. When the Constitution gets put together and signed by the Constitutional Convention, and there was all the different states that sent delegates to be a part of this constitutional convention. The Constitution wasn't the law of the land yet. It had to be ratified by each of the states' legislatures. And there were various debates and questions back and forth. And part of the Bill of Rights, which did come after, was certain things states kind of said, hey, wait a minute, we're not signing on to this Constitution without these certain things put in. One of those things, and in fact, 6 states basically put their foot down and said, we're not signing this Constitution without this clause in there. This Seventh Amendment was one of those things. And so, 6 states and sent groups back to Philadelphia saying, we have to protect this trial by jury. Otherwise, there's a danger that a tyrannical government can nullify this trial by jury because your fellow countrymen aren't convicting you the way the government or the dictator or whoever it is wants things to go. And so this was something that was very, very important to those states and to the founders, and they felt like putting it in here. I mean, we see trial by jury in the Sixth Amendment we just talked about. We also see it here more fleshed out in the Seventh Amendment, and that it's something that they're very passionate about and see it as almost a will of the people or the people's voice in the legal system, and that a judge appointed in their day often by the king or by a ruler can arbitrarily pass judgments or enforce with the iron hand of justice and not even have an understanding of the situation that those people are in, and that your neighbors and the people around you are going to have a much better idea of the situation you're in, and may also maybe not take so kindly to the laws that are in place. And so this is a key thing and something that was very important to the founders and why they actually put up a little bit of a fuss about why they wanted the Seventh and part of the Sixth Amendment. That trial by jury was very important to them.
Well, and it should be noted with the Seventh Amendment as well that as it speaks of suits at common law, and of course we're dealing with monetary values, that would put this in the realm of civil claims, not criminal claims. So there is a difference here as it relates. Obviously, people aren't paying out money on criminal claims, but in a civil claims type idea is what we would be dealing with Navigation Act perhaps as well as we go back into the history. But talking about the civil courts and trial by jury in the civil courts unless it's waived. Right, like a lot of times one might see on TV. Obviously, those are dealing with smaller amounts, but at some point you have the right to trial by jury unless you waive that right. And in a civil court type idea, it is perhaps less common for an American to think of a jury in civil court, but it is the right. And I don't know. I don't know if you're familiar. It says any controversy where it exceeds $20. Have you looked and seen if there's any sort of a weighted amount as it relates to modern day monies, or do you know if it's still a good old $20 bill that allows you to invoke that?
I think that's something we need to look into. I don't know even what the equivalency would be compared to
20 gold coins.
80s dollars versus our dollars. Inflation's it's definitely going to be a bit more.
It's going to be worse after this year.
But yeah, that's a homework thing for us to work on and take a look at.
Yeah, we'll look into that for next week and see, since we are talking about civil court and money is here, as to what maybe that, just out of a curiosity question. It doesn't really deal with the philosophy of the amendment, but out of curiosity, I'd wonder what the actual cutoff is for civil court today as it relates to the right to a trial by jury. I'd imagine it's probably not $20, but who knows? We'll know. We'll know next week.
Yes.
Any other thoughts on the Sixth or Seventh Amendment?
Well, I think it's good to dig into these, and I think these are very important to go over, even though as you, our audience, and us would we strive to be law-abiding citizens. We try to live in accordance to the law of God and the law of our country, and we never plan to be on the wrong side of the law or deal with a court case or in these type of proceedings. It's good to remember what the important things were that the founding fathers put in place, and that these are safeguards.
Yeah.
These are rights that are given, or that are the people's, and the government is supposed to protect these rights, and that these rights do come into play far heavier in a country where many other rights are being ignored, where perhaps justice is being mishandled, and that these are some of the various rights that the people should have to be able to perhaps right some of the wrongs, or have at least a voice at the table when it comes to having justice done in courts and these situations. So just because we never hope to wind up in a court of law, whether it's a criminal case or civil case, that there would be that it's good to look through these things and to remember that the founders coming out of where they did in the colonies under England, or even as they immigrated from various European countries, saw justice subverted very many times, and that, like we were talking about before, we live in a land of much freedom. People have many rights that and can use those rights, and that are able to have justice done for them, and that's a good thing. But it's a rare thing, and so it's good to remember that we live in a very privileged time, and that these things are there for our protection, and to be that protection against a government that maybe doesn't have your best interests at heart.
Yeah, well said. Better to have it and not need it than to need it and not have it, right?
Absolutely.
Very good. Well, that will wrap up our time for this 9th episode of the Wright County Restoration Project. I want to thank you for listening in once again. Encourage you, as always, if you have any questions or comments or would like to add to the discussion or have us reference something or speak to something, WCRP, Wright County Restoration Project, WCRP at legacybaptistchurch.net. We'd love to hear from you. Like, subscribe, do those things, tell others about what we are doing, share it on well, don't be on social media, but share it anyway. And we will hope that more people can think through the nature of the Constitution, how it relates to Judeo-Christian values, and look forward to seeing you all back here next week.